The new NIDS bill has been drafted and is ready for review. We want to hear from you. Go to www.japarliament.gov.jm to download a copy of the new bill. Join the conversation. Make a written submission to Clerk to the Houses, Gordon House, 81 Duke Street, Kingston, or via email clark@japarliament.gov.jm. All written submissions must be sent by Friday, January 29, 2021. Join the process. Let your voice be heard.
To listeners and viewers on TVJ, listeners on Nationwide, and also to viewers on PBCJ. This is the second of our Town Hall meetings of the Joint Select Committee on the National Identification and Registration Act. Our meetings have already started, and we have dealt with a number of matters, in particular discussing how other institutions, other areas, other personnel such as the Justice of the Peace will do some additional training and information about the National Identification System. Yesterday we had a very successful meeting. Numerous questions came in from members of the public, and we were happy to respond to as many of them as possible. But even so, this afternoon, we expect to respond and answer many of the concerns and questions that came in yesterday. And we expect that listeners and viewers will also send in additional questions to the committee. But we recognize that the bill itself has several clauses, and we're trying as best as possible to ensure that most of the clauses are being dealt with fully. So we have again this afternoon members of the team from the Office of the Prime Minister, Mrs. Sharika Hemmings-Allison, Mrs. Janelle Miller-Williams, Mr. Warren Vernon from the Office of the Ministry of Justice and Law Reform Department, Ms. Nadine Wilkins, and the Chief Legal Officer of NIDS, Ms. Kamika Facey. Joining us here, members of the Joint Select Committee, we have Ministers Johnson Smith and Marsha Smith, and very shortly we are expecting the Attorney General and Minister Favour Williams to join us. Also, we have all the other members online, so viewers and listeners will appreciate that because of COVID, a number of persons are actually joining us virtually. But all the members are aware and are listening, and so the skepticism, the issues, the concerns, everything can be brought in, and not only your questions are being recorded, but eventually we will have a matrix to examine all the suggestions that have been made. As we plan, this Joint Select Committee is to ensure that members of the public engage with the Joint Select Committee as much as possible. So we are expecting you not only to have a look at the bill, but to understand the content of the bill. So in this engagement, we are using a professional, Miss Naomi Francis, who is a professional in dealing with the public, responding to questions from the public, but at the same time, she will be putting the issues to the Office of the Prime Minister, the technical team from the Office of the Prime Minister, and also to members of the Joint Select Committee. But bear in mind that we are expecting members of the public to participate. And where any issue arises that you're not fully appreciative or understanding of, kindly send in your question so we can elaborate as much as possible. Because at the end of the day, listeners, viewers, This bill is about you. This bill is about making the national identification card efficient, beneficial to every citizen of Jamaica. We believe that this is an important card, that once you get it, you will be able to access service, not only from the public sector, but from the private sector. When you have this national identification card and you go to the bank and show it to them, we don't expect the bank or the embassy or any private institution to question its validity. Sure, they may call the authority to say, verify that this is an authentic national ID. Not a problem. But this national ID will be an efficient way of doing business in Jamaica and providing identification for everyone who has it. So it is important that every listener, every viewer appreciate the importance of this card and have confidence that in getting one, it will be beneficial to you, the members of the public. So having said all of these, we are going to go through the content of the bill, the importance of the act itself in setting up the framework to protect the data that is collected and how the data is actually used across the country and internationally. So at this time, I'm going to invite the most professional public person to interact with the public, Ms. Naomi Francis.
Yes, you are too kind. Thank you so much, and thank you to members of the public who are joining us live online this afternoon. May I welcome those who are joining us live on Television Jamaica, Nationwide 90 FM, PBCJ, and also streaming on jis.gov.jm, as well as PBCJ's website, Scene TV, of course the NIDS pages, NIDS Facts on Instagram and Twitter, and of course the Prime Minister's social media pages on Instagram, Facebook, and Twitter. For those who may be joining a little late, let me just run through the names of the persons who are on the Joint Select Committee. Of course, the Joint Select Committee is made up of members of the House of Representatives, that's the lower house, members of Parliament, and the upper house, the Senate. And those persons, of course, you would have heard from the chairman, the Honourable Delroy Chuck, as well as those on the committee, the Honourable Favour Williams. I believe Minister Williams has indicated that she will be here shortly, as well as the Honourable Marlene Malahou Fort, or Attorney General, the Honourable Marcia Smith, the Minister of State in the Ministry of Finance, the Honourable Robert Morgan, the Minister of State in the Ministry of Education, Youth and Information, as well as members of Parliament, Dwight Sibley's, Julian Robinson, Hugh Graham, Lothian Cousins, the Honourable Kamina Johnson-Smith from the Senate, as well as other senators, Peter Bunting, Senator the Honourable Aubin Hill, as well as Senator Charles Sinclair, Senator Ransford Braham, and Senator Donna Scott Motley. So thank you so much. I do believe that the Attorney General, the Honourable Marlene Malahou Fort, is online on our Zoom platform, as well as the Honourable Robert Nestor Morgan. So, Minister, as you said yesterday, we have so much to go through. I want us to take the time, especially today, to go through clause by clause. We went through several clauses, Minister, almost piecemeal, because we want to make sure that people are also comfortable in getting their questions answered, and to ensure that they get a fuller understanding. So let's then go to the technocrats in terms of a little bit of the clause by clause, and I see Mr. Warren Vernon rearing and ready in terms of clauses that have been put through, but of course our legislators are here as well to help us go through. So let's start off, Mr. Vernon, in terms of looking at the clauses and explaining through to the thinking and recommendation that you would have made to the legislators as to why these clauses are important.
Okay, thank you very much. So we can start with the objects of the bill. You want to do the objects of the bill?
Mr. Vernon.
So my colleague will start with the objects of the bill.
Yes.
Yes. So good afternoon, Chairman and members of the committee and colleagues. In respect of the objects of the bill, the object sets out the purposes of the bill. And the objects include the establishment of a National Identification and Registration Authority. Yes, and this entity shall be responsible. It is proposed that this entity will be responsible for civil registration matters and also the national identification system. With respect to civil registration matters, the bill also proposes to establish a civil registration database, which will be responsible for all the information that is kept by the Registrar General. And with respect to the national identification system, the bill proposes to establish a national identification database in which all identity information will be stored. Additionally, the bill proposes to provide for the enrollment of eligible persons, meaning Jamaican citizens and persons ordinarily resident in Jamaica, as well as to provide for the issuance of a national identification card and the assignment of a national identification number. Furthermore, the bill proposes to provide for the prevention of identity theft and other forms of fraud relating to identity information, and also to carry out the functions of the Registrar General in an office within the authority. And this office will be under the total control and management of the authority.
Wonderful. So given that then, explain for us the difference between in terms of an authority for NARA and what role the RGD will play in that whole mix as well.
Okay, so in terms of the authority, some of the functions of the authority will be to administer the national identification system and also to carry out the functions. So the purpose of the authority will be carrying out the functions of the Registrar General's department. In addition to some of the other functions of the authority will be to, some of the other functions of the authority will be to develop policies and procedures for the safeguards, security, and protection of identity information, as well as some policies, to create policies for the collection, storage, and authentication and verification of identity information.
So then, committee members and ladies and gentlemen, technical team, we went through so many in terms of skipping over clauses. We were stuck a little bit for members of the public between clauses 24 and 30. I just want to step back a little bit because we have defined authorities and meanings of establishments under this Act. I'm looking specifically, going all the way back now to just clause 4 of the Act. And again, for those in terms of persons in the public, you can go to the Parliament's website and get a copy of the bill itself, so you can go through clause by clause. Let's go to clause 4 then, and then explain really the thinking under what you have, the provisions you have put under clause 4.
Okay, thank you for that question, Naomi. In relation to clause 4 of the bill, it is proposed that the eligible persons for enrollment for the national identification system will be Jamaican citizens and persons ordinarily resident in Jamaica.
Yes.
And when we say ordinarily resident, that means that the person has been living in Jamaica for a continuous period of not less than 6 months, immediately before the date of the application for enrollment, or if the individual has a grant of leave to enter and stay in Jamaica for the purposes of study.
Yes. All right, so I'm skipping over because we're looking clause by clause as well so that members of the public can get a full understanding. Let's then go to clause 5, the National Identification and Registration Authority, and that is essentially the body that will have provisions under Section 28 based on what the bill is saying in terms of the interpretation of the Act that it shall apply.
Yes. Clause 5.
Clause 5, beg your pardon, yes.
Yes. So clause 5, right, so clause 5 establishes the National Identification Authority, which will manage the national identification system. As mentioned before, some of the main functions of the authority would be to administer the system, carry out the functions of the Registrar General, develop appropriate systems and protocols for the security, secrecy, necessary safeguards for the protection and confidentiality of information stored in the national database. In addition to providing information and advice and making proposals to the minister on matters relating to the authority, and to monitor and promote compliance with this piece of legislation and regulations. So these are some of the important functions, or some of the functions of the authority.
All right, wonderful. Something we didn't touch yesterday, and again, we're going through it in such a way today that we're able to ensure that members of the public fully understand, and then we can take some questions and be able to have a little bit more interaction, especially too with those on our Zoom platform, other members of the Joint Select Committee who are here who want to make comments, and also I believe we do have still justices of the peace who are online. Let's go to clause 6, because there is a board of management that is responsible for the setting up or the oversight, so to speak. So let's talk a little bit about that.
Okay, very well. So yes, so it proposes that, the bill proposes that there will be a board of management which will be responsible for overseeing the general administration of the authority. And some of the functions of the board will be to develop policies and procedures for the creation, management, maintenance, and operation of the National Identification System, in addition to ensuring that the authority conforms with the Data Protection Act, the Financial Administration and Audit Act, the Public Bodies Management and Accountability Act, and also other acts in relation to the management of public bodies and also the protection of identity information.
Very important point, and I want to go now to the legislators, because it's important when laws are being written that they harmonize, so to speak, that they do not offend another piece of legislation that may be there. And I wanted to turn to either Chairman or Senator Johnson Smith in terms of the importance of ensuring that reference is made in terms of safeguarding other acts that are in place and essentially making sure that they are harmonized.
Well, the truth of the matter is that when we pass laws, we recognize that they impinge on other laws. And to the extent that they impinge on other laws, if it's necessary to amend the other laws, we do so, because the laws, all the laws must be consistent. They can overlap, yes, but they must not be inconsistent, and they must not be in conflict. So that basically the NIDS Act will interfere with several pieces of legislation, and those persons who have the bill will see that in the fourth schedule, it actually interferes with several pieces of legislation, such as the Access to Information, the Aliens Act, Children's Adoption Act, Education Regulations Act. So a number of other legislations are affected, and these legislations are actually listed in the fourth schedule of the bill. And they have to be consistent, because when we look at the Registration, Births and Deaths Act,
yes,
which comes under the Registrar General, then any changes will be made at the time that this bill is actually enacted in Parliament. It is the same with the passport regulations. All of these will be affected by this legislation, so that any changes that will be made to any other pieces of legislation, the Record Office Act, the Revenue Administration Act, the Matrimonial Causes Act, several other legislation, the Marriage Act, will be affected by this legislation, and any amendments will ensure that they're consistent with this act.
Wonderful. The word consistent is really where I was going. I don't mean to put you too much on the spot, Minister of Education, and I'm coming back to the issue of the Board of Management, Ms. Williams, so don't think I've forgotten you. But Minister Favour Williams, in terms of the legislation, especially in relation to how the NIDS will affect children in particular, I mean, your role on the committee is very important in terms of also looking out for children and the youth in that regard as well. Yes.
That the act requires
Yes, go ahead.
children, requires children to also have identification.
Yes.
And children under 18 have to be guided by their parents. So when you talk about the impact on education in terms of the children, that's one of the ways that that act would impact on children.
Fantastic. All right. Minister Johnson-Smith, you're good?
There's one little point I would make about consistency. Minister Chuck spoke about the how it is that the act affects, that this bill rather affects existing legislation in terms of it requiring amendment. But I also wanted to just point out that it also preserves matters which are addressed in other legislation, like persons with disabilities.
That's very critical.
Under the Disabilities Act. This expressly says that when the NERA is conducting its obligations, that it must do so taking into consideration the needs of persons with disabilities as defined under the Act. I think that's, so it also preserves the obligations and rights and benefits which exist elsewhere. So when Chairman was speaking about how the law affects other laws, it's not only about requiring an amendment, but it's about preserving the rights that have otherwise been legislated and that are and that need to be consistently provided for in this bill. So a lot of effort has been made to identify them in Schedule 4, as Chairman pointed out.
Yes.
But they're also in other places in the bill where the preservation of the rights exists.
That's a very,
Could
very
I also
critical
add
point
to
raise.
Naomi
Yes.
that, to add to what Minister Favour Williams said, it will affect children in a very positive way.
Yes.
So that once a child is born and the registration is done by the parent or parents, then the identification card, and this is in the Education Regulations 1980, will be affected. So that on page 62 of this bill, it says, insert next of the paragraph 3, the following paragraph. 4, the national identification card may be presented to verify the date of birth of a student. So to the extent that the national identification card will be used instead of a birth certificate, it will ease the burden of a lot of parents who oftentimes in registering their children have to be getting original birth certificate. Yes, they do have the original birth certificate, but oftentimes they can't find it.
Yeah.
But when, so when you have that national identification card, you just use it
Yes.
to show that this is the identity of the student and this is the date of birth of the student.
It's practical, very, very practical in that regard, Minister, for especially parents who may have misplaced birth certificates. I haven't forgotten the members who are on Zoom, and if we could just bring up that Zoom platform on the monitor so that we can see as well, because we do have several members of Parliament who are part of the committee that we also want to hear from in terms of their perspective and their take. And of course, we have the State Minister and the Ministry of Finance, Marcia Smith, who is here as well. And I wanted to get her perspective too under some of those laws as well that we have to work, essentially make it consistent, make the NIDS consistent in conjunction with anything that has to do with finance and financial obligations as well. So I'll come right back to you, Minister Smith, but certainly I want to go back, Ms. Williams, to the issue of the Board of Management. Very, very important. I'm sorry, could you say that again? The board will?
Comprise 15 members.
Yes.
4 ex officio members and 11 appointed members. The ex officio members will include the chief education officer, the chief medical officer, the chief executive officer of PICA, and the head of the government agency responsible for child welfare. It is also being proposed that the appointed members will be appointed by the Governor General on the advice of the Prime Minister after consulting with the Leader of Opposition. The appointed members will include a retired judge of the Supreme Court or the Court of Appeal, a representative of the Jamaica Council of Persons with Disabilities, senior public officials in select ministries, a representative of non-governmental human rights organization, and an individual who has considerable experience in information and communication technology and cybersecurity. It is also proposed that there will be a chief executive officer of the authority who will be appointed by the board after the board's consultation with the minister. The board will give directions to the chief executive officer of the authority concerning the management of the authority. The bill also proposes to establish an independent oversight body to be known as the National Databases Inspectorate that will be accountable to the Parliament and the Information Commissioner under the Data Protection Act.
Could I, Naomi, just emphasize, having been a part of the examination of this bill itself, to emphasize to our viewers and listeners and members of the public that when you look at the schedule, and that is the first schedule, look at how the authority is composed, of 15 members. This is no plan authority. This is a
Since
solid
we have a global
body.
audience, Minister, you may want to explain.
This is a solid body to ensure that the database. This is to ensure that the database is properly protected. That persons feel that their data, once it is received, that it will not be, available to all and sundry, but only to those who are able to to get verification of the identity of persons. And therefore, a lot has gone into the development of this act to ensure that you have a body that is the NERA, the authority itself, chaired by a retired judge, but in addition, an inspectorate to make sure that the authority and the technical team carry out their functions effectively.
I know I see a question from a member of the public already, so let me just ask, what's the thinking behind having it being headed by a retired judge?
I think we have had the opportunity to see that many retired judges, they retired age 70, and we have utilized many retired judges. All our judges are persons of integrity, persons who have wide experience, persons who we have been able to rely on to be commissioners, not only of several parliamentary commissions, but it's an opportunity to use their professionalism, their experience, their integrity, and basically to ensure that we have someone that the country, I think 99.99% of our Jamaicans have trust and confidence in our judges. And so in using a retired judge, we feel that the people will have trust in the authority.
Thank you, Minister. Listen, we have 90 minutes for this broadcast to engage the public, and we've already spent half an hour of that 90 minutes. I wanted to also just engage those on our Zoom platform, especially those within the Joint Select Committee. I know we have Minister Robert Morgan on, as well as the Attorney General, who is also on Zoom. Their perspectives really on what we've discussed. But let me go, before we do that, to the Minister of State and the Ministry of Finance concerning just the harmonization and consistency of this particular bill to, what exists in other legislation. If you could just pass the microphone to Minister Smith, please.
Thank you. The bill as presented does take into account that there needs to be harmonization between this particular law and the laws related to revenue in the country. And if we go back to the same fourth schedule, we will see that there is something groundbreaking here on page 69, which speaks to the registration authority, that is the taxpayer registration authority, having the option to designate the national identification number as their TRN. And that, to me, will reduce the number of identifying, that will reduce the number of things that you need to identify yourself, because already we have some of that already in terms of your TRN being your driver's license.
Yes.
But to go further to say that your NIDS number will be the number that will be used for your TRN for the purposes of all your tax transactions, for the purposes of your birth, your marriage, your death transaction, will really put in a capsule all your data in one place, which will make for ease of movement and ease of business.
Ease of movement and ease of business. And really that's where the Ministry of Finance really wants to go in terms of ensuring that all Jamaica is comfortable at doing business in Jamaica. Let us, before we get to the ministers on our Zoom platform, just take you to the man on the street in terms of some questions that they had about the NIDS, and then we'll come back, of course, to what's happening on Zoom and on or other media platforms in terms of questions. So let's hear a little bit about what the man on the street has to say.
Will persons be able to use NIDS to transact businesses, or is it likely that other IDs will be required?
How quickly will the system flag identity fraud by Government of Jamaica employees or otherwise?
All right, so while we get those items prepared for you, let's then go back to the legislation then, ladies and gentlemen. And then let's look, let me skip down then to one of the issues that was raised yesterday concerning the database. And so let's go to Clause 9, National Databases Established. And Ms. Williams, you've been taking us nicely through clause by clause, so we'll ask you to continue. Yes.
So Clause 9 of the bill proposes to establish the National Identification Databases and the Civil Registration Databases. The National Identification Databases, in which all identity information collected by the authority in respect of enrollment, this is where all that information is stored in that databases. In respect of the Civil Registration Databases, all information that is kept by the Registrar General for the purpose of civil registration is stored. In terms of the use, the National Identification Databases shall be used for the following purposes: the enrollment of individuals, the storage of identity information, the generation and issue of a national identification number and the national identification card, and the verification of identity information. In respect of the civil registration databases shall be used only for the generation and issue of such certificates.
All right, thank you so much. All right, so I know that the Attorney General is on the Zoom platform and wanted to also make an intervention. So AG, good evening. It's after 6 o'clock, so yes, good evening to you, and thank you so much for joining us on the platform.
Is she on, or is she? I think she's coming here shortly. No?
Madam AG?
She may not be actually online. Yes.
Okay, let's try it.
Not hearing me?
We're hearing you
go
now.
ahead.
Thank you.
Right. I'm just saying, let us remind the persons of the information that the function.
You're breaking up, AG.
I think we're having some connectivity issues.
That are discharged by the Registrar General. So registration, births and death.
All right, so technical team, let's then get a clearer line for the Attorney General. and then we'll return to her. I believe she's also making her way here.
Yes.
Very shortly. So, of course, when she gets here, we'll take her input as well. So then, Ms. Williams, as you go clause by clause, and I know it's painstaking for some who really want to get their questions answered, but again, we have 4 other town halls to ensure that everybody gets a chance to get the questions they need answered. There is a section, and I'm telling you, it's clause 10, and I want us to go through a little bit more in detail. Clause 10 and the provisions under clause 10. Yes.
Okay. So clause 10 provides for the enrollment of individuals. It provides for an individual to make an application to the authority for enrollment. And at the time of the individual's enrollment, the authority shall inform that individual that enrollment is voluntary and that the individual may cancel their enrollment. Furthermore, the authority shall inform the individual of the reason for the collection of the information and the purpose for which the information will be used, and also the fact that steps will be taken to verify the information and what those steps are, and also that the individual is entitled to access their information and the steps required for such access, and also that the individual is entitled to request alteration of incomplete, incorrect, or misleading information. Mm-hmm. And most importantly, that the individual is entitled to appeal. Mm-hmm. Yes, appeal any decision of the authority.
All right.
Yes.
Wonderful. Can I just go quickly then to some questions, because I think persons online really are getting very anxious to get their questions in. Patrick Griffiths on Facebook asks, what legal recourse will there be available to persons whose information would have been compromised or otherwise misused? So what's the specific, is it that there is time in prison under the law? What recourse is there that's available?
Go ahead.
I know Minister Chuck or others might want to come in. I'm going to speak from the perspective of the Data Protection Act, because that is another set of laws that would, be another protection for all of us. So that, and the Data Protection Act calls for an information commissioner that would ensure that companies and government entities that handle personal data, that they abide by all the standards that are laid out in that act. The government and the companies will have obligations to ensure that there is no unauthorized access to the data. The government and companies that collect data must register and say, why is it they're collecting the data? What are they going to use it for? How long they're going to have the data? And so on. So there is quite a lot of protection. Mm-hmm. And if there's unauthorized access to the data, there are penalties under the Data Protection Act. Right. Significant penalties for that.
Could you tell us, because I think that's what Mr. Griffiths is trying to allude to. Is there a specific, in terms of jail time, that this law provides for?
The answer is yes. And that is provided for in Section 30 of the bill, so that any official of the NERA who misuse or provide information unlawfully, or anyone who provides information communicated to anyone which is not provided for in the Act, commits an offense, and a person having committed the offense breaches the duty of secrecy or confidentiality imposed by this Act, shall be liable on conviction before a parish court to a fine not exceeding $3 million. And in lieu of a term of imprisonment.
Yes. All right. I'm sorry. Yeah, could
Go
you,
ahead,
Ms. Wilkins, if you could just pick up the mic and explain a little further.
The offenses that already exist
Mm-hmm.
in existing legislation, which such as the Cybercrimes Act, the Forgery Act, the Proceeds of Crime Act. We have, in the consequential amendments to this bill, included the NIDS, so that an offense that is committed, even if the NIDS does not stipulate it, if a card, for example, is falsified, is forged,
yes.
the offenses under the Forgery Act will apply. So
Ah.
we've amended the Forgery Act to ensure that the NIDS card is included. The Lotto scam, the provision in the Lotto scam for identity theft,
Yes.
we've included the national identification number and the national identification card. If anyone seeks to falsify them for that purpose, those offenses will also apply. So we have an extensive arrangement for prosecuting offenses in every aspect of this program.
And that's what we mean when we say harmonizing legislation. Because
That's
certainly
correct.
when one won't do
Absolutely.
the work, suddenly you'll have provisions under another.
That's correct.
Fantastic. All right, there are some members of the committee who are on our Zoom platform. If we could bring them up so I could actually get some input as well in terms of explanation of what's happening. I believe I understand that Mr. Robinson is on, Julian Robinson. I'm not sure I'm seeing his ID on, but I understand that he should be on. Mr. Robinson, are you on? If you are, unmute and let us speak. All right, not quite seeing Mr. Robinson. All right, let's then continue with the clauses that we have to go through. We went to clause 10, but I want to skip to clause 14 in terms of the enrollment. Again, we come to you, Ms. Williams.
Thank you. Yes.
Naomi, just before Minister Williams comes in, hope you're hearing me.
Perfectly now, AG. Thank you. Yes.
All right, just want to say that the penalty for breaching the secrecy and handling the information is not imprisonment, it's actually a fine.
Right.
So that I believe part of the feedback that we would want to hear from persons is whether they think that imprisonment should be one of the penalty options instead of fine. Because the way it works is that if the penalty is fine, then imprisonment only comes in default of payment. So you do not get prison time. So as 30, where the provision in relation to secrecy and confidentiality exists, it says that every person who has or who has had an official duty under the Act, or who is or has been employed in the administration of the Act, or to whom information is communicated under the Act, shall treat as secret and confidential all information communicated. So it's the duty is placed on current and past employees, a duty to treat secretly and confidentially all of the information that is communicated to them. And if they disclose it, they commit an offense. But the penalty provided for is one of a massive fine, as Chairman Chuck indicated, of $3 million. So just so persons know that a fine is a different penalty from imprisonment, even though in default of paying the fine, you can serve prison time.
That's interesting.
So in some pieces of legislation,
yes,
the penalty on conviction can be both a fine and imprisonment, or it can just be straight prison time, or it can be a fine, and if you pay the fine, then you don't serve prison time. So given the critical importance of treating secretly and confidentially the information that will be communicated to you under the Act, if persons are of the view that a fine is not sufficient, then I think a recommendation can be made for consideration by the committee.
AG, thank you so much for that input, because one of the things I think a lot of persons too would want to fully understand is why just the fine and not the fine and what is the thinking then that would go on in the back section of your deliberations in terms of looking at, well, do we put this provision in an act or not that? So what's the thinking behind just the fine at this point? And of course, you're saying that members of the public can, of course, appeal to you to say, we want, one, a higher fine or a fine and imprisonment. Am I correct in saying that?
I think that's what the AG has intimated.
Yes.
Do members of the public believe that those who use unlawfully or negligently perhaps the information contained, should they get a term of imprisonment? Now, bear in mind, penalties are meant to deter. They're not really meant to destroy a person who has revealed information. But you would want to stop persons who have access to the information, such as employees, from wrongly and egregiously releasing the information to anyone. Right. So the idea is that if you do so, we're going to fine you. If it was done in a negligent manner, which is also wrong, then the court may impose a fine up to 3 million. But the person may have mitigating reasons that they did not know that they had released the information or what have you.
Yes.
So that a lot of factors come into play. But the idea is not necessarily to impose a term of imprisonment. And in all sincerity, where terms of imprisonment are imposed, it is because of the egregiousness of that offense. And in these cases, it is for the members of the public who are listening now to determine if information is wrongly released, whether it is so egregious, whether a term of imprisonment should be imposed.
Well, we have a very captive audience on social media. And just to interject, AG, before we go, that there are already persons online saying, and Leroy Fulton, I think, is leading the crew, saying a fine is like a slap on the wrist.
All right. So well, this is why, you know, the process of engaging the public is valuable. But Minister Truck will tell you that we began a reform of the criminal justice system, whereby we've been minimizing imprisonment for many offenses. Older legislation have one model and newer legislation have another model. But the duty that is placed, the duty to keep confidentially and secretly, that is placed on persons who administer the act is an absolute duty. It doesn't speak about willfully or maliciously disclosing the information. It says that you shall keep it confidentially. The information is communicated to you, you shall keep it, and you shall not disclose it. And if you do disclose it, you commit an offense.
But if I might say so, I want to agree with the AG, and I know people will disagree with us, including my colleagues here. Yeah. The truth of the matter is that we reserve, or would like to reserve, term of imprisonment for persons who pose an imminent, clear, and present danger to persons. Persons who are violent, persons who are abusive, but not necessarily to matters where a fine is a sufficient deterrent. In other words, you want to reserve term of imprisonment to persons who are volatile, violent, and definitely pose a clear and present danger.
Thank you so much, Minister. I wanted to get
Minister
to the
like
input of Minister Johnson,
have another view.
who certainly has a different perspective on the matter.
I absolutely do, Naomi. My perspective is that a fine is not always the most effective legislative penalty where it is that there could be pecuniary benefit in the offense. So if a person was incentivized to breach the obligation of secrecy for monetary gain, so if somebody was selling information for personal gain or for enrichment, it is possible that, and this is how organized crime works, they budget for the risk versus the fine. but criminal, or rather imprisonment. Imprisonment is something which is very different.
Yes.
And I feel
You
that
can't budget for imprisonment, really.
It's the only incentive. It's the only true disincentive for someone who thinks that money can be found elsewhere, whether to pay a fine, etc. I therefore think that where an offense, by its very nature, can be incentivized for monetary benefit, that is actually an appropriate offense to provide for for prison time, for incarceration as one of the penalties.
So it's likely to see...
Just to say that Minister Johnson-Smith is spot on, and it is part of a policy discussion. She's absolutely right. You know, jokingly we refer to fine and confine and confinement, but depending on how a breach is viewed, the minister is right that even a high monetary penalty may not be sufficient to punish. So there are three aims of sentencing, you know. Generally, it's to discourage would-be offenders. That's the deterrent side of it. It's also to punish someone who has actually committed the wrong. And in addition, it provides an opportunity for rehabilitation. But in cases where persons would calculate the risk and they stand to gain handsomely, and so they would wait and say, if I, for example, disclose the information and I can be paid $10 million, and I'm found guilty, and I am slapped with a maximum of $3 million, I still come out better off. So for us, we always have to look on the gravity of the offense, and in the scheme of things, where do we place a particular breach? So legislating offenses and penalties is not always very easy, even though we have been moving the justice system from retribution to restoration. And it is helpful to us as legislators to hear the perspective of persons, because I know many are extremely concerned about the privacy rights and the issues of that impact them in very fundamental ways. So if it is that the considered view is that such a high premium must be placed on discharging the duty to keep the information communicated secretly and confidentially, that any breach of it by a current or past employee should land them in prison if they are convicted of the offense. So it is a matter that the committee will take under consideration.
I think I'm hearing, not just from committee members, but also members of the public, that this clearly would be an area for detained deliberations when a final report is to be submitted to Parliament.
And this I might say is one suggestion, one issue that will be put in the matrix for further consideration.
I have a perspective from Nicole Watts on social media, and Nicole asked, well, what if the person compromises numerous individuals' identities, such as scammers? Is it that it's only $3 million in terms of the fine?
Well, each breach would be a separate, I mean, each act of communication can constitute a separate offense.
Right.
So if you are convicted of multiple counts, you know, so you can have 10 counts of murder if you kill 10 different persons. You can have 10 counts of breach of the secrecy and confidentiality provision if it relates to different bits of information. And a fine would be, a penalty is handed down on each count where there is a conviction.
AG, I want to also get the perspective of Senator Johnson-Smith, because you're talking about concurrent issues as well. Because, again, too, with scammers, it may be one incident, but several individuals. So is it that there is clarity that is needed in this particular area?
Absolutely. Okay, Minister Johnson-Smith is coming in.
Well, you know, I'm just here quarreling as usual about why it is we don't use consecutive sentencing instead of concurrent sentencing. I think there have been too many egregious crimes in this country where you hear that because the incidents, or rather the charges, arise out of essentially what is fundamentally one incident that the sentences should run concurrently. So someone who should get 36 years gets 12 because it's 3 charges, and they allow the 3 sentences to run at the same time.
No, may I just say
so I think these things
it's a
need
different
some
situation,
discussion.
Minister.
Yes. So
in respect of a fine, so the concurrency or consecutiveness of a sentence only applies where terms of imprisonment are imposed.
Right.
In respect of a fine, it would not so apply.
Right. And generally in terms in
but it is also, sorry, Chairman, it is also open to the Parliament to give an indication, though I must say the progressive thinking is that you give as much discretion to the judge. Right. Having regard to all of the circumstances, but it is properly within the policy of law to say what approach is to be taken, and more legislative guidance is being given in respect of matters to be considered.
Yeah, and there's no doubt that, I mean, you know, the judges themselves have set sentencing guidelines and sentencing policy. The truth of the matter, Senator Johnson Smith, is that I've been in many cases on appeal where judges have maintained that 2 consecutive sentences of imprisonment tend to be the norm. Rarely do you see more than 2 consecutive sentences. So that is the policy direction of the judges, and as legislators, we rarely restrict the discretion of the judges. We have done so, but the feeling is that because of the separation of powers, we'll leave sentencing to the judges.
Tamara, yes. Yes.
Yes.
Tamara Goldburn is actually saying that this aspect of the discussion really then shows that we really need to tighten up this aspect of the legislation, which is quite important. Very good. Let's go then, and we had several questions. We didn't get to this at all yesterday, to section, clause 14, which talks about cancelling enrollment under the NIDS. So let's go back to Ms. Williams, who can go through that clause, and then now we get a fuller explanation.
Okay, thank you, Naomi. So clause 14 of the bill speaks to cancellation of enrollment. In this section, the authority shall cancel the enrollment of an enrolled individual if the authority becomes aware that the individual is not eligible for enrollment, or if the individual makes the request in writing for their enrollment to be cancelled. Furthermore, the authority may cancel the enrollment if the identity information stored in the national identification databases is inaccurate.
So if you lie on that application or give the information that is false, you can automatically be taken from the enrollment. Is that so? Explain that again for us.
Yes. Okay. So all right. So what if the information is inaccurate?
Yes.
Right. Once the information is inaccurate, then the authority may cancel the enrollment.
Good. Let us be frank. Yes. We can't really anticipate too many circumstances in which the NIDS card will be cancelled. When we discuss it, we can see where persons who have come here and they're working for a period, maybe a year, 3 years, and when they decide that their employment is finished, they don't necessarily want to leave their information here, so they will cancel. But when they cancel, they must return their national identification card. But one would expect and hope that all Jamaicans will retain their national ID card.
Yes. I smile because somebody on social media said, but this is Jamaica, please. And I think we all understand what they mean by that. So then we were speaking about penalties earlier. Then what then is the penalty for someone who willingly falsifies the information given to NIDS? Is it the same issue of the fine or jail time, or is there discretion?
Under the Data Protection Act, if they try to commit a fraud, I think the penalty is quite heavy. Because the Data Protection Act, if they try to falsify their information, this bill itself provides for penalties.
Yes.
And the penalties, again, is a fine. But to the extent that they try to commit a fraud, then it may well come under the normal common law legislation, which is and could be a term of imprisonment.
You know, Minister, members of the committee and technical team, I believe to a lot of the persons...
Sorry, Naomi.
Yes, go ahead, AG. Just 1 second, though. I believe what I see a lot of persons on social media saying is that we need to just bring the NIDS bill alongside data protection so that we can see, I think persons in the general public can see a little bit more how they will work together. So we could probably do that for the next town hall in terms of looking at that as well, or maybe explain why not. Yes, AG, go ahead, please.
Well, the bill provides that a person commits an offense if the person willfully takes possession of or retain a national identification card, knowing that the card was improperly obtained, or a card knowing that the card is a counterfeit national identification card, and the penalty provided on conviction is a fine not exceeding $500,000.
Okay, wonderful. All right, I believe I'm going to ask the technical team to just get ready for the Vox Pop that we had prepared. We actually ventured out to the man on the street to hear their perspectives on NIDS and to get some questions, so I'll ask them to prepare that. But let's go quickly to clause 15. And while we talk about the number, I also want Mr. Vernon to come in and also talk about the backbone in securing that number. So, Ms. Williams, over to you.
Naomi, sorry again.
Yes.
I'm so sorry. I'm not sure if when we dealt with clause 9, we indicated to members of the public, clause 9, that the identity information stored in the National Identification Database shall be in encrypted form.
Yes.
That is not legible without decryption. Was that pointed out specifically?
It was yesterday, but you know we can go back a little bit to it because that's so important, because not many people would understand that to decrypt it would require a particular process as well. So we'll ask Mr. Vernon to pick that up, but let's look at clause 15. We go because that also has to do with the number, and then we go back to that backbone issue that deals with the encryption and decryption.
Warren,
Ms. Williams.
Okay. So clause 15 deals with the national identification number, and the authority shall assign a unique number to each enrolled individual, known as the national identification number. And this number is randomly selected, and it is permanently assigned to the individual, to the enrolled individual, and shall not be assigned or reassigned to another individual.
Yes. Yes. So in terms of the protection then of that number and the backbone infrastructure that deals with that, Mr. Vernon, could you take that up for us?
Okay, thank you, Naomi. The security of the NIDS program is hinged on the National Institute of Standards and Technology Cybersecurity framework and the International Civil Aviation Organization standards for travel document. And we are also using the ISO information security standards and also for COVID-5, all embedded in a strong security plan for the NIDS program. To simplify this is that, one, your biometric or your fingerprint and your facial image will be encrypted. Encrypt meaning that a regular person just can't access it like that unless you have the resources or the authority to decrypt the information. So additionally, your fingerprint and your facial image will be kept offline. We are only using your facial image and your fingerprint to ensure that your identity is unique and to protect your identity from identity theft. And and we would have mentioned some of them before, what we talk about significant penalties for persons who are authorized to provide services to Jamaicans, by the very nature that you work for the organization. If you abuse that, there are significant penalties, and we would have discussed some of those earlier. There's also the separation of roles, which is very important, separation of functions, and we have over 7 layers of vetting. 7 layers of vetting, meaning no single person can produce a national identification card.
Sorry, say that again
So
very clear.
Yes, no single person can generate a national identification card.
Mm-hmm.
And at the point of enrollment,
Mm-hmm.
as a safeguard, the enrollment officers will not be allowed to enter the basic identity information, which is what we refer to as your breeder document. Take, for example, your birth certificate.
Yes.
An enrollment officer will not be allowed to do so. That information must be pulled from the civil registry. And this is important to prevent fraud. Otherwise, if we allow that, then an enrollment officer will be able to create an identity for someone. Additionally, every profile or every NIN, every national identification number, which Mrs. Williams will explain in a little while, is tied to your fingerprint and your facial image. And we are also introducing the use of
I'm sorry,
Google.
and that, by the way, is something that is done standard. For example, when you take your national voter's ID,
Absolutely.
and also your passport. So it's nothing new that is required of the individual to give in terms of additional information.
Absolutely. And we are also going to fix the addresses issues in the rural areas, because in most rural areas you have a long street called Prickle Pole District, and it's a very long road. So what we are doing, we are tying Google Plus codes to our existing addresses, which will be about, I'll give you a 3-meter accuracy radius. So
if you could slow down right there for us, because this is now where the technology comes in, and I think people need to fully understand what we mean. Because across Jamaica, you have so many people with just a P.O. box, a postal agency, or a road name as an address. And this is for thousands, hundreds of thousands of people. In solving that issue specifically, how are we going to do that?
So we will use Google Plus codes to give every enrolled individual a unique address.
Yes.
And the accuracy is about 3 meters. When you look at somewhere about 10 feet, roughly approximately 10 feet accuracy. This is significant because the man living in a tenement yard,
yes.
you know, the separation, you will now be able to give that person a unique address where if you're a business person and you order a package, that package can be shipped directly to you and they will be able to find you.
Very good.
Thank you.
Very good. That sounds intriguing indeed. Before we continue with what's happening in-house, let's just quickly then go to the man on the street. We actually went out with our cameras and captured their comments and questions.
I believe this is a great idea because from a transparency standpoint, the government is living up to their first mandate to the Jamaican people to provide a clear and transparent process as we move forward to this in this age of digitization. What that means for us, or for me personally, is that I will have a better understanding from a sensitization perspective, and of course the educational piece as we move forward with these new transitions. And of course the Jamaican people will have their voices or concerns heard as we shape this bill going forward.
I think it is a great opportunity for us citizens to have a say in the very system that we will use for everyday functions. I mean, the sense of inclusion, it is absolutely important, especially now that the new NIDS policy is voluntary.
I believe that a new NIDS bill going before a giant select committee for the public to give their feedback is a great idea. As the public becomes involved, they will have a feeling that they have contributed to the passing of the bill.
The importance of this bill or this new development is for our country. They don't understand what it means for us as individuals. So I think that this is something that needs to be given to us, and then we implement strategies to educate the wider public to understand, okay, this is why we're doing this and this is how it's going to work.
All right, thank you so much, members of the public actually commenting. No questions, they're coming. Well, I actually have one from social media, not picking up yet on the point that Mr. Vernon made, but there are some questions concerning that. I have an interesting question, though, and I'll put it to the legislators from a parent, and she writes, she's Althea, she writes, I totally missed the signing. Okay, I'll give you that background. I'm seeking to know how parents who work with children can be addressed in the NIDS. There are a number of persons who parent children and want to be considered an additional parent or a step-parent per se. Not quite sure, but I believe maybe it's in terms of the issues of adoption. Yes. How will that work then?
Well, I'm not too sure that it's any different. In other words, if a parent or if a person adopts a baby, then that person would be the guardian. So I think we speak of guardians.
Yes.
So that to the extent that a child has been registered by a guardian, then that is the role that that person would play. Now bear in mind that the child having been registered by a parent or guardian, at age 18, the child is on his or her own to determine whether they want to continue enrolled, as the case may be. Or when they would change their card. In other words, we know that up to age 18, every 5 years you change your card, and after age 18, every 10 years you change your card. Now, to the extent that a guardian would advise and assist a child under 18 to get the card changed every 5 years, that is the role I see parent and guardian playing with children.
All right, very well, Minister. There are some questions that are on. Let me see. Lauren Mathura.
Sorry, Naomi. I'm just wondering whether that question is directed at the process by which a child becomes enrolled in the system, and who would do the enrollment on behalf of the child.
The responsible parent there.
That's it. It's either the guardian or the parent. The guardian or the parent.
Thank you for that input, AG. Okay, wonderful. I was actually trying to...
It has been addressed directly and specifically in the bill. Because the bill at clause 4 speaks to persons who are eligible for enrollment. And those are citizens of Jamaica. It doesn't specify age, because we do know that children can be enrolled and can be issued. But I think perhaps it's an issue that could be probed a little more, and I would ask that it be noted for further consideration to see whether something more needs to be added in respect of enrollment of children. For those parents who will opt in their children, whether some greater guidance needs to be provided for in the bill.
All right,
we dealt with that, you know.
Yes.
If you look at clause 10, you will see where the parent or guardian actually will be responsible for the enrollment. So in clause 10 itself, when you look at clause 10.4, it says this: an application for the enrollment of an individual who is referred to in subsection 1 may be made on behalf of that individual by A, if the individual is under the age of 18 years, the individual's parent or guardian, or where the individual is in the custody of a facility for the care of children, the officer in charge of the facility. Okay? And B, in the case of mentally disordered individual, then the institution.
Yeah, the institution.
Thanks, Minister.
Yes.
I think that is the kind of information I surmised the question was targeting.
Right. So it is there in section 10.
Yes.
Thank you, AG. Yes. Thank you, Minister. Right. So I was actually also, I'm happy that you intervened, because I was trying to decipher Lauren Mathura's question. It's a comment and question directed to really Mr. Vernon. And let me just give you the preamble. The Minister of Justice, or Mr. Vernon, Lauren says, with the utilization of the new address technology previously mentioned, affording everyone their own unique address, do you think this will facilitate the rolling out of more apps that require that type of data and what effect do you foresee this having on NIDS? So I think really it's Mr. Vernon.
Okay, thank you very much, Naomi. The NIDS, the intent is really to have wide-scale adoption and really to encourage innovation. But the adoption of Google Plus code is specifically for addresses and the utilization of addresses. So naturally we see where you will have more persons developing solutions that will consume that service. Yeah. And earlier today, you would have seen where the Prime Minister launched
Coding Academy.
Coding Academy. And we must bear in mind that once we develop the skill set of our people, we will be able to start, develop our own technologies.
Indeed. All right, so thank you so much, Mr. Vernon. I wanted to go to clause 16 again because I'm seeing the questions and I'm also looking at the legislation so that we'll be able to answer some of those questions ahead and the clauses that they fall under. Now, there was a question earlier, and I'm so sorry I forgot the person who was asking online, concerning if the card is stolen and if other persons can come. They prefaced it by saying, this is Jamaica. And I don't know why people are getting so cynical about this is Jamaica. But really, it's a reality that we must face and try and fix the loopholes that exist. So essentially, the person wanted to find out if the card is stolen, if someone will be able to use that card. And I think while we go to clause 16, it may have some perspectives on that for the person who was asking. Ms. Williams?
Okay, so clause 16 focuses on the national identification card. And this is where the authority shall issue an identification card to each enrolled individual. This card is to be deemed as a public document, and it is also the property of the authority. And the authority shall keep every record of every national identification card issued by the authority. And this card shall not be transferred to any other individual.
Mm-hmm. Suppose you show up with somebody else's card.
Right. So, yes.
Point to that. So the very reason for creating the national identification system is to prevent identity theft. And the reason for why it will be very difficult and almost impossible for somebody to do that is because you have to authenticate based on who you are. Mm-hmm. You have to use your biometric, and the biometric information is the key behind everything. That is where...
Facial and fingerprint.
Yes, absolutely.
So the likelihood of someone stealing the card and using the card is literally zero.
Yes.
Because if they try to use the card, anyone can see this is not your card. And in fact, the Section 16 imposes a duty on persons who get into possession of a card that doesn't belong to him or her to return it to the authority.
Oh, that's nice. Would a penalty also apply? Okay,
yes.
Fantastic. Yes, Mr. Vernon.
Yes, and additionally, the way how the system is designed is for you to always verify the information with the authority.
Okay.
The current identification cards that we have, people take them, look at the face of the card and use it. Mm-hmm. But for this, every time you use the card, you need to verify it with the authority.
Right. To be exact, Naomi, Section 16, subsection 11 says a person commits an offense if the person willfully takes possession of or retains a national ID card knowing that the card was improperly obtained. Okay? Mm-hmm. So that makes it very clear that a person having come into possession of a card that doesn't belong to him or her must return it to the authority or to the person to whom it belongs.
Wonderful. We have just 10 minutes left to conclude our discussions here. And I wanted to just go to a question also on social media concerning really the engagement of several sector leaders and to various institutions in the country. And Lauren, again, asks the involvement of the church and what we can do to get their input in future deliberations. And I do know that there is certainly engagement with the church and other institutions and civil sector society organizations. But Minister, you may be able to expand more on that.
We're hoping that in future town hall meetings that other institutions will participate on Zoom. We have had difficulty getting the Zoom to be connected to all the different institutions and agencies, but we hope in the next 4 virtual town hall meetings, a number of organizations, associations, and institutions will be able to come online and participate and engage the members of the Joint Select Committee and the technical team from the Office of the Prime Minister. But in addition, when we started our meeting this afternoon, before we came on air, we discussed how we will have the technical team having virtual meetings with justices of the peace across the various parishes, so that indeed Custis Pitkin from St. James has already booked a member of the team to have a virtual meeting with Justice of the Peace in St. James, but I did intimate to him we will include Justice of the Peace from Hanover and Trelawney, depending on the numbers. But January, February, March are basically months in which we hope that all Jamaica will be given the opportunity to participate, engage the Joint Select Committee, engage the technical team, look at the bill, so that when we debate it in Parliament, hopefully in April or May, then everyone will be aware of the contents of the bill, and if any changes are to be made or recommended, that they can be considered.
Thank you, Minister. Well, you know, this evening alone, I didn't do the tabulation for yesterday, but this evening alone, there were almost 1,000 persons on all the platforms viewing and asking questions or making comments. So certainly this is reaching, you know, far and wide, not just Jamaica, but certainly Jamaicans in the diaspora as well. And generally, they're saying they see this as a very, very useful venture. So I want to thank you so much. We are essentially out of time. Let me just, though, say that we went through, if you use a cricketing term, it was almost like a workman's batsman kind of session today, where we actually delved deep into the bill and looked clause by clause. And that's very important for members of the public to understand and appreciate really what legislators do in terms of when they have a bill before them, how they go through it to ensure that it benefits you. So we actually will stop at clause 20, and we can pick that up next week. And of course, yesterday we looked at issues of whether or not NIDS will be linked to issues with the police. And of course, we have already said no, but I always contend if you ask the questions 10 times, we will respond 10 times. So ask as many questions as possible. We will have 4 more town halls similar to this, and certainly we are ready, willing, and able to entertain your questions and comments on this matter. Thank you so much, Minister. I hand you back to your committee meeting.
Thank you very much, Naomi. And I must say to members of the public, our listeners and viewers, that the Joint Select Committee and the technical team, we are very happy that you joined us. We hope that you take the opportunity to participate in the remaining town hall meetings as we discuss other aspects of the bill. We would like you also to take the opportunity to look at the bill itself. It is on the website of the Parliament or of the Ministry of Justice, or you can ask a Justice of the Peace to try and access a copy of the bill for you, because the Justice of the Peace will be in touch with the custodies, and the custodies have copies of the bill, and they can pass it on to you. Please, viewers, listeners, convey to everyone that this bill is important. As I've said, and I will repeat, it will be a game changer. We want members of the public not only to participate in these discussions, but at the end of the day, be very eager to sign on to the NIRA, that is the National Identification System, and hopefully before the end of 2021, we will start to register and enroll persons, and cards will be issued. I feel, and we feel, that when these cards are issued, they will be effectively used to conduct business, and therefore it is important that these cards are not only efficient and you feel confident in using them, so that to the extent that this bill is good, we hope that you can assist us to perfect it even more. So please, members of the public, feel free to participate. This is an open and transparent process. You can make your suggestions. When you read the bill, if you have concerns, please express them. The 15 members of the Joint Select Committee are open for discussion, and we will be considering all the suggestions, everything that you bring up at these virtual town hall meetings, and the contributions, written contributions, will also be considered. So if you did not get an opportunity to call in or make your suggestions here, you can always write to the Clerk of Parliament or the Secretary of the Committee, and we will consider them when we start to deliberate on the bill sometime in February. I want to thank members of the team, the technical team, our secretary, the stenographers, everyone who have participated and assisted us at the second town hall meeting in making it vibrant, making it very productive. And I now ask for a member of the committee to move for a motion of adjournment. So moved and seconded. The meeting of the Joint Select Committee is now completed, and we hope that you will also join us next week, Wednesday, when we have our third town hall meeting.
The new NIDS bill has been drafted and is ready for review. We want to hear from you. Go to www.japarliament.gov.jm to download a copy of the new bill. Join the conversation. Make a written submission to Clerk to the Houses, Gordon House, 81 Duke Street, Kingston, or via email clark@japarliament.gov.jm. All written submissions must be sent by Friday, January 29, 2021. Join the process. Let your voice be heard.